Today we explore why Justice Tejas Karia stepped aside from hearing a contempt plea against Arvind Kejriwal and what judicial recusals mean for India's democracy. Justice Tejas Karia of the Delhi High Court had recused himself from hearing a contempt plea against Arvind Kejriwal and other Aam Aadmi Party leaders over alleged circulation of court hearing videos. His recusal stems from prior professional involvement with Meta and similar matters, raising concerns about conflict of interest. This contrasts with Justice Shwatakanta Sharma's refusal to rescue in the Delhi excise policy case, showing how judicial discretion operates within constitutional safeguards. Let's understand the background of the issue. The plea, which was filed by the advocate Vaibhav Singh, seeking contempt action against Kejriwal, Manish Sisodia, and others for allegedly recording and circulating videos of Kejriwal's April 13 court appearance in the excise policy case. And the allegation was it unauthorized sharing of court proceedings undermines judicial independence and violates High Court rules. And the respondents are, apart from Aam Aadmi Party leaders, social media platforms like Meta, X, and Google were also named. Let's understand why Justice Tejas Karia recused. And the reason was Justice Karia, before becoming a judge, presented Meta in similar cases involving removal of court hearing videos. And the grounds are to avoid conflict of interest and maintain impartiality. And the court order was says this matter will now be heard by this bench. Listed tomorrow before a bench of which one of us, Justice Tejas Karia, is not a member. Let's understand the constitutional and legal framework governing this issue. Article 14 guarantees equality before the law, which says impartial judges are essential. Principles of natural justice. No one should be a judge in their own cause. Nemo judex in causa sua. Judicial discretion is recusal is not mandatory. It depends on the judge's conscience and circumstances. Supreme Court presidencies in the state of West Bengal versus Shivananda Pathak, 1998, the court held that recusal is appropriate when bias is reasonably apprehended. Let's understand the precedents of judicial recusal. Election Commissioner's case, 2023. Justice Ajay Rastogi recused from hearing petitions on removal of a Supreme Court judge in the appointment of elections commissioners, citing personal reasons. And the principle is judges recuse when prior involvement, bias, or perception of bias may arise. Let's understand how this recusal is different from the Justice Shwabakanta Sharma recusal issue. Excise policy case 2026. Kejriwal himself argued for Justice Sharma recusal alleging bias. And the outcome was Justice Sharma refused, stating no valid grounds existed. And the contrast was Justice Tejas Karia recused voluntarily due to prior professional links. Sharma denied recusal as allegations were unsubstantiated. The Kejriwal contempt plea shows how judges balance fairness and perception, sometimes stepping aside, sometimes standing firm. In the end, the law allows both recusal and non-recusal as long as justice remains